Thank you, everybody, for joining us. My name is Jiyae Hwang. I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the options you can consider when moving from a visa to a green card. And many of you may be on a non-immigrant visa, such as an E2 or H1B or TN, and may wish to transition into a green card that allows you to live and work permanently in the United States. So just a few things before we get started. Scott Legal is a full-service immigration law firm, which means we have expertise handling a wide variety of visa categories suited for various circumstances. So whatever your immigration needs may be it a family-based, employment-based, or investment-based immigration matter, we can help you find a solution. We will continue these webinar series, and we are doing at least 2 webinars a month on different immigration law topics. So please follow us. At the end of this webinar, we will send out a few things to all participants. First, we will send out a copy of this PowerPoint that will be used in this webinar. Second, we will send everyone a comprehensive guide of the visa types that we will be discussing today, which is a booklet of information that has all the information you can use as a reference. Third, we will send you a link where you can sign up for additional webinars in the future, and also a link to this webinar as it will be recorded. Fourth, this webinar will be available on YouTube as well, and we encourage you to subscribe to our YouTube channel as we do regularly upload immigration law videos on a variety of topics. Finally, we will send you all a link you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case further. So today we are very lucky to have Ian Scott, who is the founder and president of Scott Legal, who has a wealth of experience in all of the visa categories that we will be speaking about today. He will be presenting about the various options available to you if you wish to transition from a visa to a green card, and what are the main considerations. Finally, for any questions you may have, please do feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will turn it over to Ian.
Great. Thank you very much, Jiyae. It's great to be here. And yeah, as Jiyae mentioned, many of you may be on a non-immigrant visa, like an E2 or TN or H1B or L1, and you're looking for a way to make your stay a little bit more permanent, right? So we're going to go over a number of the common categories. And then also some categories that are a little bit more obscure, but nonetheless, it seems that every year we do at least one of them. So before we jump into the different types of green cards in detail, a couple of things I want to share. So one of the things is that every single topic that we go through and every single visa category that we go through today, we could devote an entire webinar to that topic. And in fact, sometimes we do. Jiyae mentioned we regularly do these webinars, and for many of these topics, we have separate webinars that cover in detail the requirements of that particular green card category. So definitely what we'll do here is that the review will be much more high level, but you can sign up for one of those webinars in the future, or you could go back to our YouTube channel and look at past webinars on those particular topics. So the second thing I wanted to talk about is, just before we get into the specifics, just kind of how the green card system works in the United States, because it is a little different from a lot of other countries, and arguably a little more difficult to get permanent residency in the United States. Now, when I say that, I mean that a lot of other countries have a system in place where it is in essence a points-based system, where you get points for things that the government finds desirable. So, for example, if you speak the language, if you have a certain amount of education, youth, there are a number of different, certain professions. There are a number of different things that the government can give you points based on, and then when you have enough points, you can apply for some type of permanent residency. Another factor that a lot of other countries use as well is how long has the person been in the country on some type of valid visa, right? Where the US doesn't consider any of that. In the United States, the system is such that there are a list of green card categories, and if you are eligible, you can apply, right? So each green card category has criteria, requirements, and then you can apply. So someone could be in the United States for 20 years on a non-immigrant visa, and that's not going to help them at all with respect to any of these particular any of these categories, because the individual would have to look at one of the green card categories and make an assessment as to whether or not they qualify under that particular category. So then the further kind of breakdown is, and we are going to talk about a little bit more than this, kind of very quickly go over some other categories, but the two main areas of green cards fall under family-based green cards and employment-based green cards. And when we look at the family-based green cards, they're further subdivided into what's called an immediate relative category. And that's not immediate relatives in the way we would think of them normally. It's a defined term. So a US citizen marrying someone is immediate relative, or a US citizen over 21 that is sponsoring their parents is an immediate relative. But if you were sponsoring, for example, your sibling, that's not considered an immediate relative. It is defined by immigration. And instead, that falls into one of the preference categories. So there are a number of different categories, like, for example, unmarried child over 21, sponsoring a parent, things like that. So so now we'll talk a little bit more about the family-based. So then the employment-based categories are broken down into 5 categories, right? Going EB1 through EB5. The one that we're not going to really talk about at all today is EB4, which is a religious-based green card, but we will touch on all of the other categories. So let's jump into family-based. We'll use family-based to kind of describe a couple of concepts in the green card and immigration system. So, as I said a few minutes ago, there are 2 categories: immediate relatives and preference-based categories. Now, the biggest difference between these categories, other than there's just a defined difference, like, in terms of who can apply under which one, is that the immediate relative category is always current. So what do I mean by that? I mean that the way that the system works is that the government, through congressional law, has carved out the number of green cards that can be issued in each of these categories that we're talking about. And once that number is hit, once they've issued that many green cards, then people start to go on, we'll just call it a waiting list, right? So their green card, they can still apply, but they're on a waiting list. So for example, under the preference-based category for siblings, if a US citizen wanted to sponsor their brother or sister, the wait is around 14 or 15 years, right? So long wait, very, very long wait. And many of the preference-based categories have that long wait. Now, we don't see this in the immediate relatives because those categories are always current. So if you're US citizen marrying someone, always current. Child, US citizen over 21, sponsoring parents, always current, right? But think of those, that concept. It really follows through to all of the green card categories that we're talking about, even employment-based. So, if we looked at one of the employment-based categories, then we're saying that the government was permitted to issue X number of visas in that category per year. And once that's used up, then people go on a wait list. And the wait list is becoming a big problem, as you'll see when we get to some of the employment-based categories. But unfortunately, it is a fact of life and something that is entrenched in congressional law, so can't be changed unless there is some type of comprehensive immigration reform. So now the other thing to consider and to think about in terms of utilizing this family-based category for concepts is that when someone is getting a green card, they have 2 ways of getting it. So one way is that they are going to consular process. So if they're outside of the United States, or if they're inside the United States and they want to process the green card at a consulate, that's one way. The other way is that if you are inside the United States, you can do something called adjusting status. So when you adjust status, you can apply also for employment authorization and travel authorization, although those 2 documents take some time to be approved. So, we're going to talk a little bit more about these, consular processing and adjustment status. And usually in terms of the decision as to whether or not you apply for them, which one you apply for is going to be, dependent on strategy. Because if you apply for adjustment status, for example, and you can't avoid travel, then that's not going to be a good category for you, because once you apply for that, you have to wait until your travel authorization has been approved, and that could take 10 to 12 months for it to be approved. So we go through, what the needs of the client are, and then kind of make a decision on which is the best. But the adjustment of status, you do have to be in the United States to be able to apply for that. So when we look at, kind of moving from a non-immigrant visa category, sometimes someone's on a TN and they meet a US citizen and get married. And, that's, we had a person today who sent us a picture of her citizenship. She's a citizen now, and she did an E2 visa with us. So she was on an E2 visa for a period of time, I think over 5 years. She married a US citizen. She did the green card process with her under the immediate relative category, and she just completed the citizenship just today. As a matter of fact, she sent us a picture of herself with her certificate saying that she's a US citizen now. So that's, that's definitely one way. And then you also have a lot of people that are willing to wait for the preference-based categories. Sometimes the wait was, 10 years, and they applied a long time ago. And during that time, they've had non-immigrant visas. And now their time for an immigrant visa has come up, and then they're able to apply. So the first employment-based category that we're going to talk about, and this, as I mentioned, that for all of these, like we have an extraordinary ability webinar that covers just EB1, NIW, and O1 that goes into these in a lot more detail. But the EB1 category is really a category where we're saying that it's a green card category where we're saying that an individual has risen to the top of their field, and in order to prove that, you would look at the 8 criteria that are listed here in the bullet points, and you would have to prove at least that you meet at least 3 of them, right? So now, it might look easy in the sense of, oh, I only have to meet 3 out of 8, but it is a very, very high bar. Right. So it's the analysis that we have to do is that you've met 3, but then even when you meet 3, the government can say, well, yeah, you met 3, but we want to do this overall look and see if you rise to this subjective level of having extraordinary ability. And if you don't, then they can deny the petition anyway. So now what we tend to see for this category, that in terms of moving from a non-immigrant visa, is that there's a very, very similar category under the non-immigrant visa types, which is an O1. So an O1A is very similar, and O1B is similar enough. So often when we are moving people to EB1A, often they were on an O1 before, not all the time, but often they were on an O1 before, and maybe they, have more accomplishments, or they've risen to the level of being able to apply for the green card, the higher bar, because even though on the face of it, it looks like the requirements are very similar for EB1A, and in particular O1A. On the face of it, they might look very similar, but it's EB1A is really O1 squared, or O1 times 100 or 1,000, or something like that. So the bar is definitely a lot higher. The one great thing about this particular visa category, and visa and green card are used interchangeably, is that you can self-petition. So you don't need an employer for this. So you do have to make an attestation that you're coming to the US to do the thing that you have an extraordinary ability in, but you can actually self-petition. So that's great. And we do these for entrepreneurs as well. We have a gentleman that we just did this for, and he was approved under this category, and he is an entrepreneur. So definitely, I think that some of the kind of unique considerations or things that might come into play is that an individual might have been accepted in some type of incubator program, and that might be similar to receiving some type of award and different things like that, or the individual's has attracted investors and things like that. But often often I'd say that although we consider this sometimes when people are on an E2 visa, moving them from an E2 to a green card, we consider this sometimes. I'd say that more often than not, it is when someone is on an O and they're moving into this category. So we talked already about the two-step process, and it's always going to be this two-step process, like one, process which deals just with the requirements, and the family-based petitions is going to be an I-130. Where's your marriage certificate if it's a marriage-based filing? If for the employment-based categories, for most of them, it's going to be an I-140. So that's going to the I-140 is going to be where you prove that you've met at least 3 of these criteria that are listed here. And then we move to the second step of the process of whether the person is going to be doing consular processing or adjusting status. And so that's always that, we're going to, the same considerations we're going to look at, is the visa category current. So the gentleman I mentioned to you before, he was approved under, we actually did an O1 for him first, and then we did an EB1A for him, and he was approved with both, with no RFP for either. But his category is not current. So he's still waiting. He has the O, so he can continue to live and work in the US, but his category is not current. So we're still waiting to file the I-485 for him. And there hasn't really been any movement in several months. I think he was approved last year, and there hasn't been any movement in many months. So yeah, this is definitely something to consider if if media is speaking about you, you've published in journals, you've judged the work of others, you have a really high salary or high compensation, you have the lead role in organizations. It's definitely something to consider. Now, the other, another green card category that we, and this one, we work with a lot, and in particular, moving people from E2 to this category. But there are many different visa categories that this particular green card category should be considered for, and it is a national interest waiver, so EB2 national interest waiver. Now, the crux of this is that you are coming to the United States to do something that the government feels is nationally important and has substantial merit, right? So so we're going to look. First, when we do an NIW petition, national interest waiver petition, the first thing that we ask our clients is, what are you coming to the U.S. to do, right? So define for us what your actual endeavor is, and then we ask them, well, why is it that why do you think the government will feel that is important? And it could be obvious. It could be that the government has said that they feel it's important, right? And they could point to government policy statements that where they say that they feel that this is important. It could be that people have written about it in journals and papers, saying the importance of the particular thing. It could be obvious that it's important in terms of just intuitive that it's important. One case that we look at often when we're looking at entrepreneurs was a gentleman who was starting a small consulting company that dealt with assisting vets that were returning from combat. And the person was able to point to all of these newspaper and government articles and different things like that have indicated that the government has had an interest in making sure that the vets are taken care of. So those are you're going to look for those types of things. Then you're going to look at whether the individual is well positioned to advance the endeavor. And this slide does say entrepreneur, but it can be anything. This can be, a scientist. It can be a run-of-the-mill company, and we could be relying on jobs as the nationally important thing. And sometimes we might be relying on multiple things to be the national important thing. But we're going to look to see if the person is well positioned to advance the endeavor. So we're going to look at their educational background. We're going to look at their resume. We're going to look at how far along are they at getting what it is that they want to accomplish. Have people been investing in it? Do they have a patent? Are people, is this something that people are going to be interested in and is going to take off? The government in this category really likes to see a track record, like a proven track record. So if it's, a company might, is the company capitalized, but also has the person done something like this before? Have they done something like this in their home country, or are they well positioned to do it in this country? Even if it's an entrepreneur, we might be looking at, have they been accepted into, an incubator program? Do they have external investment? All of those things are going to show that the person is well positioned to advance whatever it is that that they're trying to do. Because often things that people are trying to do cost money, and if you have the money and then you say, okay, well, I'm going to be able to do this because I have the money, then that's something that is going to be helpful. Often we would be putting together a business plan. Business plan, if it is for a company as well, putting together a business plan that might point to jobs that are being created, but also the business plan may give some flavor with respect to how and why the person is well positioned to advance this. And then the third requirement just has to do with a lot of the time for the third requirement, the government should waive the labor certification process. So normally under this category, the government requires companies to go out and prove that they can't hire US workers, and they have to obtain a labor certification. And the government has said that that is nationally important because they want to protect US jobs. So we're going to be putting all sorts of arguments in here, often repeating the arguments a lot with 1 and 2, but then we also will point to anything special about the individual. So we might borrow from EB1A, anything special about the individual to say, well, why is it that the government should waive the labor certification process? And we'd utilize that. But the two key elements are point 1 and 2. I think that I'd be hard pressed to see a petition denied where the government said that the person has met criteria 1 and met criteria 2, but failed to meet criteria 3. So the other thing to kind of keep in mind is, as I said before, like we could talk for hours about national interest waiver, but we don't have hours, so we won't. Then the other thing to kind of keep in mind is that this particular category does fall under the EB2 category. Remember when we went through them, we said EB1 through EB5. Now EB2 category does have threshold requirements. The individual has to have an advanced degree or a bachelor's or equivalent, which is bachelor's plus 5 years of progressive work experience, or exceptional ability. Like we get a lot of people who contact us and they say to us, hey, I have an advanced degree, so I'm eligible for EB2 national interest waiver. Where do I get my green card? And this is just a threshold requirement. So it's or, and it's all or. So it's if you have a master's degree, which, master's degree or higher, then you stop there. So you don't have to go further. If you don't have a master's degree, or higher, then you have to look at the bachelor's degree plus 5 years experience. If you don't have that, like let's say you only have a high school degree, then you have to look at whether you have exceptional ability. And that takes us back to looking at certain criteria that are similar to the criteria under extraordinary ability, but different, easier to meet. But that's the other way that you could move into this category. But that particular analysis, we do it first before we even look at the 3 prongs that I just talked about. Okay, so another way that people move from non-immigrant visas to green cards is a company will sponsor them for a green card, right? So you could be working on a TN, or you could be working on an H-1B for a company, and a company could sponsor them. You could want to sponsor you for a green card, and that's probably the most common way that people get green cards in the United States. If you're on an E2, your own company can't sponsor you or your spouse. However, what we've done a lot of is that the E2 applicant's spouse, gets a job because he or she is going to be able to work in another company. They have work authorization. They get a job, and then that company sponsors them for a green card, and then the E2 applicant can follow in that process as well. So the PERM process is a complicated and long one, but it's lots and lots and lots of PERMs are processed every year. And basically the company that is sponsoring you is proving that that they can't find a qualified US worker. So the first step is that there's a job description, and it's not a real job description or a normal one in the way we think of job descriptions, because it only has to list the absolute minimum requirements for the job, and you can't have any subjective things in there at all, like good interpersonal skills or anything like that. The job requirements are usually basic. They're bachelor's degree in X plus 2 years of experience in Y, right? They're usually just basic like that, right? Like minimum requirements. And you can't just bolster the job description so that they're exactly matched what the applicant has, because you could, get an audit or denied later. So then you have to actually post that job and let people apply, and the people apply, and your company actually interviews them. There's no real job, right? It's your job. No real job, but the company actually interviews them. And if they find a qualified US person during that process, then they have to stop the process. Like, and if they found a person that had that bachelor's degree in that field and had 2 years of experience in that particular, you can't disqualify them because they didn't present well, or they didn't speak well, or they didn't, that's not permitted. If they meet the minimum job requirements, then you would have to actually stop the perm at that point. You can apply again later, but you'd have to stop the point. Often there are like these triggers as well that's if you like have the job requires a foreign language, for example, that's almost certain that your perm is going to be audited, because that particular requirement in the United States would exclude probably 90% of applicants, or maybe even more. The timing fluctuates, so we won't spend much time on that. But again, it's going to be the same petitions that are filed. There's a perm that's filed with the Department of Labor, but once that's approved, you're going to be filing the I-140 with USCIS, the immigration, and the I-485, and/or doing consular processing. So the EB-5 is, as I said, we're skipping EB-4, right? So it's a religious-based visa. We've never done one, and I don't really know anything about them. The EB-5 investment is one that often our clients who are on E2 visas, will do this. But then also other visa categories as well, because if the client has, money, they can invest in a very passive form of investment and get a green card. So it's a wide range, and we do a lot of these. So the idea here is that the person's investing 800,000 or 1,050,000 in a new commercial enterprise. New commercial enterprise is a business that started after 1990, so it's not just have to be new. And the difference between the amounts, 800,000 and the 1,050,000, is that the business has to be, if the business is located in a targeted employment area, which is either a rural area or an area where the unemployment rate is 1.5 times the national average. If that's the case, then it's a lower investment amount. If not, it's a higher investment amount. The kind of big looking at there are kind of two ways of doing it: direct investment or regional center. So the regional center is very, very passive. So you're going to basically giving someone who's like, say, building a hotel that wants to raise like $600 million, and they're going to be taking in a bunch of EB-5 investor money to do that. Low return, but the person doesn't have to do anything because they're going to be creating the jobs that we'll talk about in a second. But then direct investment might be the individual has their own company and they're investing the 800,000 in their own company and then creating the jobs in that company. So that's this is a very, very complicated area. Yes, we do have webinars again on EB-5, and it's some of the bullet points. I'm intentionally not kind of going through them in a lot of detail because they do require a fair amount of explanation. You'll find that like most immigration attorneys don't do EB-5s. We do, but most immigration attorneys don't, because they are very complex. So it's the other thing with respect to this is, as I said, we move a lot of people from E2, is a source of funds. Like, you do have to show where the money came from. And although E2 has a source of funds analysis, the EB-5 source of funds analysis is extremely complex. So it's probably times 1,000 if you were kind of, if E2 was 1, this would be on a scale like 1,000, because it's quite an exercise. The other kind of piece with EB-5 is you have to create 10 full-time jobs, and they have to be US citizens or green card holders. The money that you invest, there has to be a link to job creation. So often, some of the times when people, like if they have an E2 and they purchased a business, then that may not qualify for EB-5, because EB-5 requires that the money is invested in the actual business and then used for job creation. So the first step of EB-5 is an I-526 petition, and then depending on where you are, you'll do the I-485 or consular processing. And then after you get the green card, 2 years later, you actually have to file another petition proving that you've actually created the US jobs. So some of the more obscure categories, way people move from non-immigrant visas to visas. The first one is diversity lottery. Like there's every October you fill out a form, and in May they select 50,000 names, and then you can get a green card that way. And we seem to have a large number of clients with a lot of luck. So we usually at least one a year we do, where a client has some type of non-immigrant visa, and they win the diversity lottery. We're doing one right now where the person won in May, and she was an E2 client in the United States on an E2, and it just seems that this is quite common for us. Then there are some humanitarian-based green cards, like if you witness a crime, or if there's green cards that you can get if you are a victim of spousal abuse and things like that. So there are kind of some others, and then there are others that not used that often, like asylum. You can get a green card through claiming asylum, but again, that's not that common in terms of our practice anyway. It is common. It's not common in terms of our practice. And then of course immigration reform is something that is not sure if or when we'll ever see that, but definitely we can always hope, right? So the final thing is that with moving from moving from a visa to a green card, and especially if you're in the United States, you always kind of have to consider and give thought to timing considerations, because some of these petitions take a long time to be approved. EB-5 petitions take over 4 years to be approved. Now, there is some basis to be able to stay in the United States, while the petition is being adjudicated, but you do have to kind of make sure that as you're applying for a green card, that you're looking out for, when does my next non-immigrant visa come up for renewal? Because if the government knows you're going through the green card process, you may have a bit more difficult time, actually renewing your non-immigrant visa so that you're able to stay in the United States. And so all of that has to be considered in terms of your travel considerations and things like that. Because some visas are what are called dual intent, like an H-1B, an L-1, and O-1, but then others are not, like TN and E-2. So you do have to be careful when you are entering the United States, re-entering, applying for visas, and then if you for example, enter the United States, then immediately apply for a green card and file an adjustment of status applications. You do have to kind of plan accordingly and make sure that you're following all of the rules, because sometimes with the green card categories, there sometimes are interviews as well, and they will harp on some of those rules with respect to, like, if you choose the adjustment of status option, they may harp on some of those rules. So perfect. So that is everything for this. And as you know, I know I've said it many times, but I'll say it one more time, is that for each of these topics, definitely feel free to check out our webinars on the individual topics, because like I said, on EB-5 we do both a direct investment and regional center webinar, NIW, extraordinary ability. So there, all of these, we do have separate webinars where we cover these topics.
All right, so let's see if there's any questions. I don't see any that came up, so it must be that Ian, you just covered everything so comprehensively that there were no outstanding questions. All right, so in that case, we can certainly close. This has been very helpful, and I'm sure this has been very informative to our attendees. And as Ian mentioned, please do feel free to sign up for our upcoming additional webinars where we go into additional detail about each of these categories. All right, then everyone have a good day. Thank you so much for your time, Ian.
Thanks, Jay. Thank you. Okay, take care.